The letter arrived on a Tuesday afternoon, folded once too many times and stamped in red like it wanted attention. I almost tossed it aside with the grocery flyers and cable ads, but one word jumped out immediately: foreclosure. I laughed at first, actually laughed, because the balance listed underneath it was $200.00. $200. That was it. No missed mortgage payments. No liens from the bank. Just my HOA, claiming I owed them late fees for a landscaping violation they'd never properly explained. I figured it was a bluff, another scare tactic meant to bully homeowners into quick payments. I didn't know yet that they were serious, or that this would end in a courtroom with Judge Frank Caprio staring directly at them. This wasn't my first run-in with the HOA. Over the past year, they'd sent me vague notices about my lawn being out of compliance, even though it matched every house on the block. No photos. No measurements. Just warnings and escalating fees. I emailed back asking for clarification and proof. Silence. Then another letter. Another fee. By the time I demanded a formal breakdown, the balance magically reached $200, mostly penalties stacked on top of penalties. I sent a certified letter disputing the charges and asking for a hearing, exactly as the bylaws required. They never responded. Instead, they sent the foreclosure notice. What made it worse was the tone. The letter wasn't just legal, it was smug. It warned that failure to pay within 10 days would result in loss of property rights and forced sale to recover HOA costs. Over $200. Less than a utility bill. I called the HOA office and was routed straight to voicemail. I emailed the board president, Karen, the same woman who once threatened to fine me for leaving my trash can out 30 minutes late. Her reply was short and cold: pay what you owe, or the process continues. No discussion. No hearing. Just power. I started digging. That night, I pulled out the HOA bylaws, state statutes, and foreclosure rules. What I found made my stomach drop. In theory, they could initiate foreclosure for unpaid dues, but only after specific notices, mediation attempts, and a board vote. None of that had happened. There were no certified warnings. No recorded vote. No chance to contest the charge. They skipped every step and jumped straight to the nuclear option. Either they didn't know the law, or they thought I didn't. The next letter came a week later. This one was from a law firm hired by the HOA, demanding payment plus legal fees, now totaling over $1,100. That's when I stopped being scared and started being methodical. I gathered emails, timestamps, photos of my yard, copies of the bylaws, and proof of my certified dispute letter. And when the court summons finally arrived, I noticed one name printed at the top of the assignment sheet. Judge Frank Caprio. I didn't smile yet, but I knew this was about to change. What the HOA didn't know was that their entire case rested on paperwork they never followed, and Judge Frank Caprio was about to ask them one simple question they couldn't answer. The first thing that struck me when I read the HOA's court filing wasn't the legal language, it was the confidence. They didn't hedge. They didn't explain. They declared. According to their paperwork, I was a chronically non-compliant homeowner who had ignored repeated opportunities to resolve outstanding balances. That alone was enough to push them toward foreclosure, they claimed. I reread the sentence 3 times, flipping through my email records, because I had done the opposite of ignore them. I had written, called, sent certified mail, requested a hearing. Their story wasn't just wrong, it was completely inverted, and they were submitting it as fact. Karen's signature sat at the bottom of every page. HOA President. Her name appeared again and again, authorizing fees, approving legal action, certifying compliance with the bylaws. What shocked me wasn't that she signed it, it was that she signed all of it. No minutes from a board meeting. No vote records. No proof of homeowner notification. Just her word, stamped with authority. It became clear that this wasn't an HOA decision. It was her decision, and she was daring the court to question it. A week later, I received an email from the HOA's attorney. It was framed as a courtesy outreach, offering to settle the matter if I paid the balance plus legal fees. The message warned that going to court would only increase costs and risk irreversible consequences. I replied with 1 paragraph and 4 attachments. My certified dispute letter, the return receipt, my unanswered emails, and the section of the bylaws outlining mandatory dispute resolution. The response came 2 hours later, shorter, colder, and dismissive. Asterisk, our client maintains its position. Asterisk, no acknowledgement. No explanation. Just power, again. Meanwhile, the neighborhood started whispering. Someone had seen the legal notice posted online. Another neighbor stopped me while I was checking the mail and asked, quietly, if everything was okay. That's when it hit me, this wasn't just about money. It was about reputation. Foreclosure notices don't say, HOA dispute. They say, failure. And the HOA knew that. They were willing to let the entire block think I was losing my home over $200 rather than admit they'd skipped their own rules. The night before the hearing, I laid everything out on my dining table. Documents, emails, photos, timelines. I didn't know how Judge Frank Caprio would rule, but I knew one thing. Facts mattered in his courtroom. I rehearsed answers, not speeches. Dates, not emotions. Because somewhere between Karen's signature and the law firm's threats, the HOA had crossed a line. And if the judge asked them to explain how they followed their own procedures, they were going to have a problem. By the time we walked into Judge Frank Caprio's courtroom, the HOA was smiling with confidence, but they had no idea the first question he was about to ask would dismantle their entire case. The courtroom was quieter than I expected. No dramatic music, no raised voices, just the soft shuffle of paperwork and the low murmur of people waiting their turn. When our case was called, I stepped forward and took my place at the table, heart steady but alert. Across from me sat the HOA's attorney, flanked by Karen, who looked completely at ease. She leaned back in her chair, arms crossed, chin slightly raised, like this was a formality already decided. If there was any doubt in her mind, she didn't show it. Judge Frank Caprio entered without ceremony, took his seat, and scanned the room with a kind of calm that instantly demanded attention. He didn't rush. He didn't posture. He simply looked at both sides, nodded once, and asked the HOA's attorney to summarize the case. The attorney launched into a polished explanation about unpaid dues, chronic noncompliance, and the HOA's unfortunate but necessary decision to pursue foreclosure. As he spoke, Karen nodded along, occasionally whispering something under her breath, clearly confident the narrative was landing exactly as planned. Judge Caprio listened without interruption. He didn't take notes at first. He just watched. When the attorney finished, the judge leaned forward slightly and asked a single question, quiet, precise, almost conversational. Counsel, can you show me where the homeowner was given the required opportunity to contest these charges? The attorney froze for half a second too long. Papers were shuffled. A binder was opened, then closed again. Your Honor, he said carefully, the HOA sent multiple notices regarding compliance. Judge Caprio didn't raise his voice. He simply followed up. That wasn't my question. Karen shifted in her seat for the first time. The judge turned his attention to her next, asking whether a formal board vote had been taken before initiating foreclosure. She answered quickly, too quickly. Yes, of course. The board agreed. Judge Caprio nodded, then asked for the meeting minutes. The smile on her face faltered. She glanced at the attorney, then back at the judge. I don't have them with me, she said. The courtroom felt smaller suddenly, like the air had been pulled just a little too tight. When it was my turn to speak, Judge Caprio addressed me directly, his tone even and patient. I explained that I had disputed the charges in writing, requested a hearing, and never received a response. I handed over my certified letter receipt and email records. He examined them carefully, then placed them neatly on the bench. He didn't react outwardly, but something had changed. The pace slowed. The judge wasn't just listening anymore. He was measuring. Judge Caprio leaned back and looked at the HOA's side again. Foreclosure is a serious remedy, he said calmly. Especially over a sum this small. Karen tried to interject, but he raised a hand, not sharply, just enough. You'll have your chance, he said. And for the first time since this started, she looked unsure. As Judge Frank Caprio turned back to the HOA, his next question wasn't about money, it was about authority, and it was one they were completely unprepared to answer. Judge Frank Caprio folded his hands and looked directly at Karen, not with anger, but with the kind of focus that made it impossible to dodge the truth. "You're telling me," he said slowly, "that this board authorized foreclosure, yet you can't produce a single document showing that authorization." Karen straightened in her chair and tried to recover her composure. She insisted the board had discussed the issue informally and that everyone was on the same page. The judge raised an eyebrow. "Informal discussions," he replied, "are not the same as lawful action." The HOA's attorney attempted to steer the conversation back to the unpaid balance, emphasizing that dues, no matter how small, were mandatory. Judge Caprio listened, then leaned forward again. "I understand that," he said. "But my concern isn't whether dues exist. It's whether the process was followed." He pointed to the bylaws I had submitted earlier. "These rules aren't suggestions. They're requirements." The attorney hesitated, then admitted that certain steps may have been condensed due to time constraints. The word hung in the air. Condensed. Judge Caprio repeated it quietly, as if testing its weight. Karen tried to explain that strict enforcement was necessary to maintain order in the community. She spoke faster now, her words overlapping, her tone defensive. She claimed that allowing one homeowner to challenge fees would open the floodgates. That's when Judge Caprio stopped her. "This court doesn't operate on fear of what might happen," he said firmly. "It operates on what did happen." He asked her again, clearly, whether I had ever been granted the hearing guaranteed under the HOA's own rules. Karen opened her mouth, then closed it. "No," she finally admitted. The judge exhaled slowly and turned a page in the file. "And you moved to foreclose anyway." It wasn't a question. Karen nodded stiffly. Judge Caprio shook his head, not dramatically, just once. "Do you understand the gravity of that action?" he asked. She replied that she was acting in the association's best interest. The judge's tone softened, but his words didn't. "Sometimes," he said, "people confuse authority with power. They are not the same thing." At that point, Judge Caprio announced he was taking a brief recess to review the record. The courtroom emptied slowly, conversations hushed and tense. Karen didn't speak to her attorney. She stared at her phone, jaw clenched. I sat quietly, replaying the admission in my head. No hearing, no vote, no documentation. When the bailiff called us back in, the judge returned with a folder tucked under his arm and a look that made it clear his decision was no longer uncertain. As Judge Frank Caprio took his seat and looked straight at the HOA, it was obvious. This wasn't just about dismissing a case anymore. It was about consequences. Judge Frank Caprio adjusted his glasses and looked down at the file one last time before lifting his eyes to the courtroom. The room went still. "This case," he began calmly, "should never have been brought." He explained that foreclosure is one of the most extreme remedies available under the law, and using it over a $200 disputed balance, without following mandatory procedures, was not just improper, but dangerous. Karen's shoulders tensed as he spoke, her earlier confidence long gone. The judge's voice never rose, yet every word landed with unmistakable weight. He turned to the HOA's attorney first. "Your client failed to provide notice, failed to provide a hearing, and failed to demonstrate board authorization," he said. "That alone is enough to dismiss this action with prejudice." Then he looked directly at Karen. "You signed these filings," he said evenly. "That means responsibility rests with you." She tried to respond, but Judge Caprio raised a hand gently. "I've heard enough." The silence that followed felt heavier than any gavel strike. Judge Caprio dismissed the foreclosure immediately and ordered the HOA to remove all fees and penalties related to the alleged violation. He then addressed the legal costs. "This homeowner was forced to defend against an unlawful action," he said. "That is not equitable." The judge ordered the HOA to cover my court costs and warned that any further attempts to collect the disputed amount without full compliance would expose the association to sanctions. Karen stared straight ahead, lips pressed tight, as if hoping the moment would pass faster if she didn't move. Before closing the case, Judge Caprio leaned back slightly and offered something unexpected: advice. "HOAs exist to serve communities, not intimidate them," he said. "Rules are meant to create order, not fear." He paused, then added, "When power is exercised without fairness, it stops being authority." The words weren't angry. They were disappointed, and somehow that made them hit harder. Karen didn't look at me as the judge ended the session. She gathered her papers in silence and walked out without a word. In the weeks that followed, the fallout spread quietly. The foreclosure notice vanished from public records. Neighbors began asking questions. A special board meeting was called. Karen resigned before it ended. The HOA sent a formal letter apologizing and confirming a zero balance on my account. Life returned to normal, but the lesson lingered. Because sometimes the most powerful moment isn't shouting or revenge. It's standing calmly in front of the law and letting it speak for you. If you're ever told you have no choice, remember this: there's always a choice when the law is on your side.